Morning, everybody, and thank you for joining us this morning for this Lightstone and SSLR seminar and webinar. We want to actually just take you through a little bit more information around the Property Practitioners Act and POPIA, which is your Protection of Personal Information Act. So just to bring everybody up to speed in terms of what's happening in both of the acts so that everybody's informed and has the right information. We have a jam-packed morning this morning. So I'm going to be starting with the PPA and then going on to the POPIA Act. So also just for everybody's information, just in terms of a survey, we will have a survey happening towards the end of the webinar, and we will then also send you an email with a survey. So you will have an opportunity to give us feedback, which is most important, and we value it. So please do that. And then once again, questions, any questions, please just put them in the chat, and Esiani will field questions between each section for us and kind of guide us in terms of the questions coming up most, and questions that we don't get to, we will respond and get back to you afterwards. So to start off with, we're going to start with the Property Practitioner Act. So to join me on this is Silna. So let me just do a quick intro for Silna, and I'm sure everybody's familiar with Silna. So Silna completed her LLB degree in UNISA, after which she was admitted as an attorney in 2007. She co-founded SSLR, where she began to specialize in evictions. And I'm sure everybody in this field will then have worked with Silna or know Silna. She has a close relationship with industry shaping bodies like the Institute, SAPOA, Rebosa, and the PPRA. And she presents training, provides legal opinions and advice on behalf of these bodies. So welcome, Silna. It's lovely to have you.
Thank you so much, Hayley. It's so much fun to be with you. And it's an honor to share a webinar with Lightstone. So thank you very much for this. And I'm really looking forward to today's session. I know even though it's almost been a year since the promulgation of the PPA, there's still so many questions. So thank you so much for this.
Great. So probably to kick it off, what is the PPA?
Well, I was wondering what kind of questions you're going to throw at me, and that luckily is an easy enough one to deal with. So the PPA, I must say, I'm always amazed at our industry. We have the gift of abbreviations. I think of all industries, we are one with the most. We have like PPA and PPRA and who's what. So the PPA is the Property Practitioners Act. The Property Practitioners Act was already, we already were pretty much familiarized with it in 2019. We then waited for the regulations to be promulgated, and that's why it happened so quickly. I think everybody was a little shocked at how quick this act was promulgated, but it wasn't actually such a big surprise. 2019, the act was promulgated partially, and we waited for the regulations to be promulgated for the entire act to come into working, and that happened in January, on the 14th of January this year, and the act was promulgated in full on the 1st of Feb 2022. Remember, we were all sort of still waking up in the new year, and then it was like, bam, okay, there's it, Yella. Now we're awake. We hope you have your second cup of coffee in. So the Property Practitioners Act and its regulations that goes with it, crucial. An act can never be seen alone without the regulations going with the act. Otherwise, it doesn't really make a lot of sense. So that's a very long answer to a quick question.
That's fine. And most importantly, why was it created?
So it's mostly for protection of consumers. Remember, we say for protection of consumers, and us as the industry players are like, okay, but what about us? Like, yay, consumer, but what about the property practitioner? What about the estate agent? And the thing is, as much as the main focus is around consumer rights and protection of the consumer in the property industry, it's actually very much for the protection of the property practitioner. Now, guys, don't hop off the call or, throw your screen with tomatoes. That would just be silly. Just hear me out on this one. The reason why I'm saying one of the big focus points of the Act is also protection of the property practitioner is actually around regulation. Remember, as frustrating as it is for you as the property practitioner who has to jump through hoops to get your FFC, who has to comply with all these rules and regulations, it also means that the guy next to you that doesn't have an FFC, the guy that's an illegal trading person that can charge much lower commission because he doesn't have to pay any fees anywhere. He's just like a cowboy running his own show. That person is now regulated as well. And the question is always that I get from the industry, why on earth isn't the PPRA doing something about these rogue practitioners at a much larger scale? And the answer is we need to report them. I know from my side, obviously not registered with the PPRA, but with the LPC, the Legal Practice Council. And I am one of the biggest fans of reporting other legal practitioners to the LPC. If I see somebody is, you know, not treating a trust account as they should, or not acting professionally as an officer of the court should, I'm one of the first people to report to the LPC, and that's why I need to keep my hands extremely clean, because if you want to be the clicky back head girl, then you need to make sure you don't accidentally smoke behind the bathroom, right? So the same goes for property practitioners, exactly the same. If you know there's somebody doing short-term holiday rentals without an FFC, you can't sit back and be sad about the PPRA not taking action against that person if you don't take the necessary steps to report that person. How on earth will the PPRA know about an illegal practitioner practicing in Kuruman and they are based here in Gauteng unless you report it? So it is for regulation. The Act came into being for regulation of practitioners as well as protection of consumers. It's a very important piece of legislation.
Cool. And maybe just to clarify for everybody, we had obviously the EAB and now we've got PPRA.
So exactly the same thing. The EAB, well, the Estate Agency Affairs Act was repealed in full. That means struck out, doesn't exist anymore. There isn't parts of the Act that's still alive and well. It's dead. And it's important to be aware of this. So it was repealed, struck out, replaced in full by the Property Practitioners Act. And it's as a result of that that the EAB is gone and the PPRA is now the regulating body. It's true that the EAB and the people from the EAB stepped immediately in as the PPRA, but I think we've all have a close eye on media as well. And we know there's been a lot of changes there. Currently, the acting CEO is Delhi, and she is doing really a sterling job. I am very impressed with the work that she's doing, and her heart is really in it. I think she has a massive pile of stuff to work through, but they are making progress. And we need to remember, if you take over as a CEO of a company that's been in a bit of disarray, it might take some time to really get around to it, but it is now the PPRA, and there are still a lot of people from the EAB, but we can see under the new leadership, things are definitely looking up for the PPRA.
And if we look at the definition of a property practitioner, who does it actually include?
Must I lawyer the answer, or can I keep it simple?
Probably keep it simple.
Okay, yeah. So grateful. Okay, the definition, why I'm asking, Ailey, the definition of property practitioner is so long. If you're struggling to fall asleep, seriously, save money. You don't need those sleep story apps. Everybody really does, but just hear me out on this one. You don't need that. You just read the definition of property practitioner in the PPA. I promise you, you'll be asleep by, sentence number 3. Short version is, if you are a person dealing with property, transacting with property on behalf of a third party, and you receive remuneration for that function. So easy. Are you a third party, or is this yours? Is it your company? Is it your trust? Is it your own property? Or are you doing it on behalf of a third party? Hayley, you and I are good friends. We've known each other for years. But if I start renting your property out, I am a property practitioner. I am fulfilling the duties of a property practitioner. If, however, my company, and it is my company or my trust, and I am renting it out, then I'm not fulfilling a duty of a property practitioner. If you own a property in your personal capacity and you're selling it, you're not a property practitioner. So it must be on behalf of a third party, not just the holding entity. You must receive remuneration for that, but that doesn't mean you can do it for free as a gift. And weirdly, people just pay for your kids' school fees. That's remuneration, guys. And that's not just trying to sneak around an FFC. That is also known as big F word, fraud. So try to avoid that. You look so worried. So it's very important to be aware of this. So third party trading with a property on behalf of somebody else for remuneration, that is a property practitioner.
And also, just to clarify, so it includes, excludes MOs, so your mortgage originators, excludes attorneys, excludes sheriffs of the court, excludes banks. They, I would presume, are all governed under other acts.
Under the, yes, exactly. And their own governing bodies. I recently had a question where somebody asked me, what about an attorney that's trading as an estate agent, as a property practitioner? And I actually think it's a good conversation to have, if you don't mind. Let's deal specifically with attorneys. Yes. Remember, we have FFCs. As an attorney, you must register with the LPC, the Legal Practice Council, and we have FFCs under the LPC. Your trust account, the reason why attorneys can act as estate agents, just saying, I will never in my life, I respect the work you do, and I love hanging out at your functions and doing training, but that's a job that I don't think is good for anybody's heart. So I don't know why people do this, but obviously there is a good reason for a lot of attorneys to also act as property practitioners. They do not need an FFC from the PPRA because you are exempt from that as an attorney, because you have a trust account that must be audited, and you have a fidelity fund certificate, not with the same fidelity fund. This is now a fidelity fund with the Legal Practice Council instead of the Property Practitioners Act. So very different, but you can't have two trust accounts. If you are, however, a non-practicing attorney, you do not have a trust account. One day, way back when you studied law, you accidentally got admitted as an attorney. These things happen to the best of us. You got admitted as an attorney, you never went on the practicing role, or you were on the practicing role, but you don't have a trust account. You cannot just act as an estate agent, as a property practitioner, because you are an attorney. The trick is you need a trust account, and your trust account must either be regulated by the PPRA or by the LPC, and it can only be one of the two. I suppose there might be attorneys out there that only has PPRA FFC, and that's FFCs, that's also all right with the non-practicing attorneys. But as a practicing attorney, you will only have one FFC, and it's okay. You don't need a PPRA FFC as well. Sure, that was a lot of abbreviations. It sounds like I'm rapping.
And then also, just to confirm, so who needs to register as a property practitioner?
So every single person that falls within the definition of a property practitioner. If you are wondering, say for instance, you're doing something weird, you're doing sourcing and you've heard from other people that you don't have to or whatever, approach the PPRA, register, or if you really feel like I'm doing something that's really in a gray area, approach the PPRA and ask for exemption. You tell your entire story, you tell the PPRA what's happening, and they will either say register or you are exempted. So if you feel that you're sitting in a gray area, don't assume ach nee toe maar, rather approach the PPRA, ask for exemption, and you're coloring properly within the lines. Because if you don't, there are quite a few rough things that can come your way. So rather err to safety side on this one.
And then also, just to confirm, what is new under the PPA?
How long do we have again, Hayley? Like 5 o'clock this afternoon. Okay, let me highlight a few of the biggest ones. I'm going to leave the mandatory disclosure form for the end of my list, because I think he is a conversation on his own. But the thing is, for the first time ever, it is one of those things where we have a lot of new things where the property industry is actually regulated around BE, around tax certificates. I kid you not, guys, this is the year 2022, and to be honest, we're really heading towards the end of him. But we're already in the year 2022, and until Feb this year, we weren't regulated on BE. You didn't require a tax certificate to practice as a property practitioner. That's a little wild, guys. I know everybody's upset about it and a little up in arms about it, but the truth is, it's almost bizarre. If you look at all the other industries, it is very well regulated. We must definitely look at transformation in our industry. I am very close to quite a few of the transformation, a lot of the groups and the entities that's focused on transformation in our industry. Absolutely essential, guys. We can't sit back in a country and say, oh my goodness, unemployment, but we do not uplift entrepreneurs and property practitioners to the, which is a very strong place for entrepreneurs, to the way we should. So BE certificates for the first time ever. Currently, we don't have a BE rating requirement. So you need to register your company for a BE certificate. You need a BE certificate. I very often get the question, Hayley, do I as a person need a BE certificate? And the answer is quite simple. No, you are a walking BE certificate. You look at me and you don't think, wow, look at that level 1 chick. It's, you know, I mean, it's not really something you can issue on a person, it's on a company. So get your ducks in a row. Tax clearance is a requirement. Remember, tax clearance takes quite a while to get sorted. So now's a very good time to get everything in order for yourself. It's anyway, as somebody with a trust account, to not have your tax affairs in order, I must say, raises a few questions. So apologies for all the toes I just stepped on. But it's anyway important to get those things in order. So that's brand new. And then all the fines and regulations around practitioners trading without FFCs, dealing with disciplinary action. And I must say, I think we're all so focused on, oh my goodness, why are the exams moving and why are we taking so long to get our results? Where actually, if you look at what the PPRA has been busy with, when it comes to regulating this industry, there's actually been quite a few trials already with people that trade without FFCs, people that's acting negligently. And I think we also used, and I say this with the necessary respect, we also used to, in the past, you report a matter to the EAAB, maybe it goes on a disciplinary hearing, maybe it doesn't. At this stage, they're finalizing complaints within 30 days, I kid you not. So that's their mandate. And they are actually finalizing those complaints in 30 days. Sadly, I have seen a few of the people that I'm aware of in the industry falling on the wrong side of the 30 days with quite a few fines. And I think it's important to be aware of this. The disciplinary action under this act is much more stern and much quicker. And then obviously a limitation on the time period in which an FFC has to be issued. So I know this is a contentious issue, so again, don't stone me, please. But the FFC must be issued in a period of 30 days. And I'll agree this one is an interesting one. But if it is not issued in a period of 30 days, you are then deemed to be issued with an FFC. So there is a massive speed situation force on the PPRA. But I think as time goes by, they'll definitely be able to be in line with the requirements from the Act. And then obviously the mandatory disclosure form. Is there anything else specifically, Hayley, that you want to point out before we move to the mandatory disclosure form?
No, I think you've covered the tax, you've covered the changes in the trust accounts, auditing, no. And I think mandatory disclosure is really interesting. So, yes.
And mandatory disclosure form, I struggle to see why everybody is up in arms about this one. It's an obligation on the landlord or the seller. And The problem is I've been very passionate about written mandates forever. I think since the day I walked into this industry, I've been saying, why don't we have written mandate agreements? What is this? Because the biggest sadness and fights that we see in the industry between property practitioner and landlord or seller is about commission. Now, if you have a written mandate, you know exactly what your commission is, what you need to do to earn that commission, and it's not even almost a question about whether you're going to get your commission or not. The parties agree to this. Now, Section 67 comes in and it says a property practitioner may not accept a mandate without a mandatory disclosure form. So it's not one of those things where you have the mandate and now you need to nag the landlord or the seller for this mandatory disclosure form. This is the first document. So when the guy calls you and says, will you please list my property? The answer is, yes, sir, of course. I just need this mandatory disclosure form because legislation says I am not allowed to accept your mandate without this mandatory disclosure form. It's absolutely crucial. What do we do when a landlord doesn't want to give you the mandatory disclosure form, or the seller? You cannot accept the mandate. It's as simple as that. It's almost like saying, oh, but I really don't want to pay tax. I feel you. I really do. Even me, and yet here we are. You may not accept a mandate without the mandatory disclosure form. Now, mandatory disclosure form, say for instance, a seller or a landlord that's living abroad. How do we deal with that? Thank goodness for independent inspectors and third-party inspection companies. There's a million amazing inspection companies out there. I think that's one of the big things, Hayley. I think you've seen it as well. Yes, since Feb this year, such a strong focus on inspection companies. So get an inspector in, do the mandatory disclosure form, because if you don't, what Section 67 says is, if you decide, it's fine, I'm just going to accept this mandate, I'll roll with the punches, let's see where we're going to land on this one. What the Act says is, if the tenant or the purchaser then suffers a financial loss of any sort or any other damages as a result of this property transaction, you see how wide this is. This is super wide. Mm. Then you, as the property practitioner, can be held personally liable. So it's not the company, it's you with your own money. So say, for instance, the landlord said, the seller said, I don't want to do this mandatory disclosure form. And turns out there's termites or a massive leak or something that leads to massive financial loss. They are going to come knocking at your door. Your FFC will not cover it, because remember, your FFC does not cover professional negligence. And it is professional negligence to not do a proper mandatory disclosure form. Ensure that you have it. It's not your job as the property practitioner to go and do it. If the landlord or the seller did not disclose a defect, and now that is the result of the damage, but you've asked for this mandatory disclosure form at the time of mandate, now you are protected. You can step back and say, well, Mr. Landlord, I really tried to guide you through this, Mr. Seller. You had an opportunity to disclose. You didn't. So guess what? This entire damages claim falls squarely in your lap, and you as the property practitioner is completely safe. Hayley, I don't know about you, but I've heard more people complain about this and then I haven't. And I understand why. I understand landlords and sellers doesn't want to do this. But that's the thing about regulating an industry. Imagine, for instance, way back when we didn't need to have prescriptions for certain medication. Okay, I'm very sure the pharmacists were also like, oh, nobody's ever going to want to do this. You hear what I'm saying? It's regulating an industry is essential, but doing it is painful. So let's work together. And again, if your neighbor doesn't take a mandatory disclosure form, report them to the PPRA and tell the PPRA this is happening. You are losing mandates because of this guy. You can't sit back and moan and post nasty things on Facebook. That's not going to help you. You have to take the correct, necessary action.
And Silna, I would imagine, I've heard cases of owners that own property in the country but live abroad. So they're actually not here to actually know what's wrong with the property. So in that case, if a property practitioner fills in the disclosure form, it obviously then sits with them from a liability point of view, and they can't be doing that. So they need to then engage with the owner and make sure that they are giving information to the owner that is true and real. How do they manage that?
Sure, this is a very good point, because if you do it on behalf of the owner, you take more responsibility than just leaving it. So this is quite scary. That's exactly where I would put the owner in contact with a third-party inspector. Good. Put them in contact and step away. It's not your job. And if you do this job, it's quite scary. It's like a pharmacist saying, don't worry, I'll quickly help you with this open heart surgery. Just because you know where the heart is doesn't mean it's a good idea that you do this operation. So same for the property practitioner. The fact that you can inspect definitely means that you should not be the one completing that form. And your signature may not be on that form in any other place than property practitioner. You must sign it to show that you've accepted it and to protect you, but you're not allowed to complete that form on behalf of the owner. Get a third-party inspector. Very important point, Hayley. Thank you.
Good. And then we've had a couple of questions around how do I apply for an FFC?
Luckily, on the PPRA's website, on their portal, you can apply electronically. I think that's the easiest way of doing it. I'm very sure if you hop in your car and drive there, you can do that as well. But you can apply online, and that would be the quickest and easiest way of doing this. You will have to upload a few supporting documents. You're going to have to do your tax certificate, your BEE certificate, so get those things in line, and you're going to have to provide the PPRA with those, but it's an online process. I haven't done it myself, obviously, because I'm not a property practitioner.
And have there been any changes around the FFC?
Yes, and cool ones, very cool ones. And FFC will now be valid for 3 years. So remember, everybody's up in arms. This is why I don't comment on Facebook groups on property practitioners, but I see what everybody's on about. One of the big things is some of them were issued now until 2024, some until 2025. Remember, your time period, exactly the same as with attorneys, runs from the 1st of July. So if you apply before the 1st of July, it will only be until 2024. If you applied after the 1st of July, wait for this, it will then be until July 2025. So just look at your dates there. And if there is an issue, get in contact with the PPRA. They will fix it, but it's a date thing. So they will be valid for 3 years, which is absolutely fantastic compared to the 1 year in the past.
Cool. And maybe just to recap around, so you mentioned that transformation goals is a big criteria for the PPA. What are these goals? So what are the main elements of it?
So the main elements is actually, I hope everybody on this call know me well enough to hear my heart on this one, but the goal is not to tick any BEE boxes. The goal is true upliftment, true education, and true mentorship. I work closely, Ailey, you know, with most of the national groups, and I see the heart of so many of the groups where they say, we want to pair an established and experienced property practitioner with a young, Black, brand new, coming into the industry practitioner. True mentorship, not box ticking, not I have been with this guy for so many hours, log booking, not box ticking. I've said it a few times now. True transformation, true skills transfer, and true upliftment. I am deeply passionate about this country. I think everybody knows this by now, but this is what we want to see. We want to see entrepreneurs being built, and we do want to see young, if it's an older Black person but new in the industry, you count as young in my head now, young, new Black property professionals truly rising to the industry and being part of our industry. You can It doesn't take a rocket scientist to look at our industry and really realize that we're not transformed in the way we want to be. So I actually also want to challenge everybody to think about this and look at the guy next to you, the new intern coming in, a young Black intern. Take that person under your wing. You've had experience for years. Do the skills transfer, show the communication. The heart of our industry is relationships. Remember, nobody in our industry has ever succeeded without having a heart for the people that we're working with, without having, we selling and renting homes. We create spaces for people to live. We're a heart industry, so have a heart for the young new Black property practitioner coming in, and let's uplift this industry together, because it's necessary for South Africa. And that's definitely at the heart of all of this as well, Hayley. I can see the way the PPRA is thinking about this, but the NPPC, the entire industry is looking to tap into the industry score being our hearts, and we want to be able to share our knowledge and our experience in the industry with Black practitioners, so we can create entrepreneurship and promote that and really bring up our industry to where we want it to be, so it deserves its spot in the economy, as it should, because I believe we are one of the cornerstones.
Cool. Thank you so much. That's a very well-rounded answer. And probably just before we jump into questions, because I see there's a couple of questions coming through, so we'll get connected with Estiani now shortly. But just to confirm around audits. So we've heard that the PPA are actively doing audits. Maybe you can just fill us in.
Yes, so I've actually had quite a few of the officers that I work with, that I train, and obviously responsible for their documentation being audited. So what they're looking at is obviously the mandatory disclosure form mandates, obviously where the money is going, what's happening with your trust account. And on leases, remember, I'll always go back to the rental guys. You know, you're my favorites. So the rental guys, they do look at what your lease agreement says about what is happening to the deposit. So remember, interest accrued on your rental deposit in terms of the Rental Housing Act should accrue to the tenant, except if there's an exclusion in terms of the Estate Agency Affairs Act. Now that act was repealed. So what we're saying is, what if your lease agreement is saying, so most of the agents that I work with, you know, you're on the same lease back that we all love and are very close to our hearts. So in that lease back, I specifically deal with the deposit accruing to the tenant. I've removed the option to allow the deposit to accrue to the property practitioner, because remember, it could never accrue to the property practitioner. It was only accruing to the Fidelity Fund. Now, unfortunately, I know there's been a few practitioners in the old days that sort of took a fee from the deposit. That's not allowed, not in terms of the Estate Agency Affairs Act or the Rental Housing Act. So I've removed that. Keep it simple. Let the full interest on the deposit accrue to the tenant. Obviously, you are allowed to charge a deposit handling fee if there's any fee that you need to pay for the handling of the deposit, your bank charge or system fee that you need to pay. Just make sure you deal with it in your lease agreement. And this is one of the biggest things they are auditing. What is happening to the interest on your rental deposits? And then obviously your documentation. Do you have a clause in your lease agreement or your OTP stating that you have a valid FFC? If you don't, guys, please take a look at those things. I'm very proud to say all the officers that I know of that's been audited, that's using our documentation and that I'm working with closely, they've all passed with flying colors. Got a bit of a script when they got the call to say they're getting audited, but if your documentation's in order, you can't use lease documentation or sales documentation because you are comfortable with it. I'm so sorry to be that person, but your contract is not about you. Your contract is about, do you fulfill the requirements of the law? You can't remove rights parties has just because you don't like those clauses. So make sure your documentation's right, make sure you deal with your deposits right, and obviously keep your trust account very clean and safe. And so from the audit, Sally, I've seen a few fines. Usually the fines are around 25,000 Rand. Also practicing without an FFC. So unless you have 25,000 Rand you want to spend, make sure your documentation is in order, your trust account as well, because trust account not in order is not just 25,000 Rand, that could also end up in a bit of an orange jumpsuit. And let's be fair, nobody really looks good in that bright orange.
No. Thank you, Silna.
Pleasure.
So what we're going to do now is we're going to jump to the questions. So Estiani is going to help field that, because obviously I haven't seen any of the questions. So Estiani is going to answer some of the questions with Silna, and they can take it from there.
Awesome. Thank you, Hayley. So yeah, we have quite a few interesting questions. I think let's start with 3 questions around the mandatory disclosure form. So the first one was, Section 67 does not prohibit agents from accepting a mandate without a disclosure form, and does not stipulate mandates have to be in writing. So I think, Silna, it'll be good to maybe just quickly chat around that. And then the second part to that is, does the mandatory disclosure form need to be worded exactly like the PPRA have provided, or the PPA? Because some of the questions may be confusing and have a little bit of a negative connotation. So if you can maybe just answer those 2 for us.
Estiani, I love those questions, because Section 67 and the interpretation around that has been heavily disputed up to this point. And I think what not everybody, what a lot of people are looking for is almost a bit of an escape out of it. But the act, how an act should be interpreted is, when you read a piece of legislation, let's think what the intention of the legislature was. So if you look at personal liability, if the legislator comes in and he says, you need to do this, and if you don't, you can be held personally liable for your inactions. Now, the logical, easiest interpretation of that piece of the legislation is, let's do that. You cannot have a mandatory disclosure form that's not in writing. There's a massive dispute around, should your mandate then be in writing? Should it be attached? What I'm saying is, why risk personal liability if the act is clear and the intention is clear that it is better for everybody to have your mandate in writing, to have your mandatory disclosure form attached to it? Because if you don't have it and your interpretation was wrong that day in court before that judge, you pull that personal liability, I would have said, let's rather stay on the safe side of the law. So yes, we can argue for days about interpretation, and I suppose that's why courts are there, right? If interpretation of legislation was that straightforward, we wouldn't have had so many courts dealing with interpretation. The act is pretty straightforward, and if you interpret it in the way you read it, you can see that the intention of the legislature is to have the mandatory disclosure form at the time of conclusion of the mandate agreement, failing which you obviously run the risk of personal liability. Then again, each to his own. However, if it's my client and my advice, or me personally, I would make sure that I complete the mandatory disclosure form, mandate in writing, and attach the one to the other. Regulation 36 then deals with the form in which the mandatory disclosure form should be. It doesn't have to be in exactly the same form. So remember, all regulations to legislation does have draft examples of things. It's almost like, there are so many examples to this. It could vary, but it must consist with the content of the form. So that must be consistent, and you need to make sure that you tick all the boxes in the content, not necessarily the form. But for instance, if you want to change the language, say you want to use one of the 11 official languages, go for it. It's not going to be the exact same thing. I mean, even if we just look at the regulations It is in English as well as Tivendas. So if you want to do it in Zulu, Xhosa, whatever your heart desires, it's not exactly the same, but your content carries the same message.
Awesome. All right. So I think there's two short questions that is still very valid in terms of the mandatory disclosure form. And the first one is obviously who pays for that. And the second one is, can, as an example, a tenant complete the disclosure form on behalf of the seller, which I think is very important to just get clarity on.
Definitely. So if you have a third-party inspector that does the mandatory disclosure form, the owner must pay for that. The owner must complete it. So if the owner doesn't complete it, then the owner must pay for whoever completes it. Remember not to do it as the property practitioner. Tenant can never do that. This is an obligation on the owner. It's almost like selling a car. You can't sell a car and be like, oh, I don't really feel like being the one that's going to have a look at it. And so it's your stuff. It's your responsibility that you're selling or renting out. Owners need to be educated, landlords and sellers, that you can't take a back seat in an investment property. It's your responsibility. So always the owner.
Awesome. Thanks, Silna. And then maybe just around who needs, you've spoken extensively around who needs an FFC and who needs to be registered. So one of the questions was, is an owner allowed to rent out his or her property without being registered? And you've cleared that up to say, yes, they do not have to be registered. But then follow up on that, there's quite a few questions around the admin person in an office that doesn't necessarily get commission. So does an admin person have to be registered with the PPRA?
Love the question. As soon as the admin person is involved in the transaction, if you are just the admin person, let's take, for instance, I think everybody knows my personal assistant by now, Natasha. If Natasha is like my brain walking outside of my body, Natasha is my PA. Natasha can do anything for me. Natasha can run my diary. Natasha can book my flights. Natasha can do my slides. She really does. Natasha is basically me. But Natasha is not an attorney, so she is not allowed to give legal advice. I have a Fidelity Fund certificate. I am the practicing attorney. As soon as you contact my office and one of my admin ladies gives legal advice, we have a problem. Same with property practitioners. If your admin lady is truly an admin lady and she does, she records the payment, she issues the invoices, what, lekker. She is not giving any advice. The moment she picks up the phone and she says, I am going to do the credit check, or I am going to negotiate on behalf of the landlord or the seller, or any transactional element or any advice element, now we have a problem. So administrative functions, as long as it's that, then it's good. The moment that person actually becomes, it turns into a situation where they are fulfilling the duties of an agent, they do need an FFC, no doubt about it.
Awesome. Thanks, Silna. I'm not sure how much time we have left for questions, but one other question that does come up quite a few times is around holiday letting and holiday homes. So if you could just maybe touch on that, you know, what is the setup there? Who needs to be registered? Who does not? I believe it falls in the same ambit as whether it's your own or whether it's not your own. But if you can just give us a bit of clarity on that as well.
Estiani, I must say I'm so glad you asked this question, because this one blows my mind completely. Everybody understands whether it's commercial property, residential property, you know, retail, industrial, doesn't matter. Everybody understands if you are trading with a property on behalf of a third party, you must be registered. And for some reason, yellow short-term holiday rentals, and everybody's like, yeah, but I have it on Airbnb for somebody else. Yes, you are transacting on behalf of a third party. I do not understand why the term of the rental or the nature of the property makes anybody believe, I say this with respect, makes anybody feel like this is their not property. It's property. You are trading with it on behalf of a third party and you are receiving remuneration for it. I struggle so much. I've had this conversation actually with Delhi as well. I said, Delia, I do not understand why this thing about holiday rentals is out there. So those hosts that host on Airbnb or which other platform on behalf of a third party, they must most definitely be registered as a property practitioner. I know there are people out there that delivers a service, for instance, on these platforms where they help you to make your ad look better, but it's more a graphic design function. Happy with that person not being a property practitioner. It's a graphics function. They take nicer photos, they tell you which photos to use, what to say about the property. But when it comes to actually concluding the agreement with the people that's going to rent the property, that is the owner, and that person does not need an FFC. If you are hosting on behalf of a third party, you are a property practitioner, and most definitely you need an FFC. If you have a full hotel mandate, for instance, on a full hotel, most definitely you need an FFC, and you need to be registered as a property practitioner to rent that out on behalf of a third party.
And where would they report agents or people that do actually transact in that manner but are not registered?
The PPRA. The PPRA, and they will take it up with that. I think that's a good question. I think very often I feel like, but this person's not registered with the PPRA. How does the PPRA have authority in terms of the act they do? And the PPRA will find that person properly for acting without an FFC.
Okay. Awesome. Hayley, do we have time for some more questions, or shall we move on?
We probably need to move on, but
okay,
if we have time at the end, we can certainly jump back in.
Awesome.
I think all these questions are really important, and we do want to answer them. So cool. Thanks, Estiani. So Estiani heads up our real estate at Lightstone, and you'll see her in the next Q&A with POPIA. And Silna, thank you very much for your information on PPA. It's hugely valuable, and the industry really values the insights, and it helps understanding in terms of what's actually come in.
It's a pleasure. Thank you.
And now moving over to our POPIA. So Protection of Personal Information Act, and we know that that's been in the cards for a while. And I'm joined today by Linda Reed. So Linda heads up data at Lightstone and has deeply delved into POPIA and really been the officer for us in this. And she's going to be answering some questions, and we're going to have some dialogue around some of the changes. But just to introduce Linda, so Linda's joined Lightstone in 2015, and she headed up as commercial lead for spatial and retail. And she has now moved into the property data team through the evolution, and obviously has a great passion for data and insights, and is really helping Lightstone position itself correctly. So Linda, thank you. Thank you for your time. Shall we kind of kick off and start?
Great. Thanks, Hayley. And thank you for inviting me. I'm very happy to be part of this webinar. POPIA, I guess a lot of people, just to introduce again what it is and why it's important and why it's enforced. Our South African Constitution is acknowledged as one of the best in the world, and it contains a section that gives everybody in South Africa the right to privacy. Without a way of enforcing that, it's actually meaningless. And POPIA is now the law that gives force to everybody's constitutional right to privacy.
Cool, thanks, Linda. And once again, it's always a question: are we the only country that needs to control use of personal information?
Absolutely not, Hayley. This is with an increase in the digital age, and with data being so much more accessible with computing and cloud and everything else around digital kind of sharing of information. Most countries have a privacy law, and those that don't will need to soon, because the availability of data in the digital space makes it so much more open to abuse. So aside from the reinforcement of people's right to privacy, privacy laws actually help to regulate how data can be used, and therefore identify how it can be misused and protect people from the misuse of their personal information. Commonly, where fraudsters try to use people's PI to steal a lot of money or to otherwise do harm to individuals.
Really interesting. And also with the law being in effect for 1.5 years now, we actually asked our property practitioner clients whether they'd been able to do all of the changes that were required for their operations.
And have most of them been able to adapt appropriately?
It was interesting in terms of the response. So 2/3 said that they had, and 1/3 reported that they hadn't been able to complete all of the required changes.
Okay, well, this is a very, very far-reaching and a very deeply impacting law. So I'm sure that a lot of companies in South Africa are still busy working on adapting. But it's another law that's kind of got a list of instructions where you can just tick a button or tick a to-do kind of item and say that you've done something. It's actually needs companies to determine for themselves the extent to which they need to adapt and how they need to adapt. And it also requires them to regulate themselves, therefore, against the law. So that is a little bit difficult to start with when you're unfamiliar with the law, which is why we always recommend that people consult with lawyers who are experts in POPIs if they have any difficulties in understanding how to adapt. But it's understandable that it takes a while, given that's the nature of the law.
We also, in the survey, we also asked our clients what they found the most challenging components of POPIA were.
So let me guess, I'm guessing that direct marketing was one of the things that people are finding most difficult.
That was definitely at the top. And then second to that was the 8 conditions for lawful processing, which came up. And then third to that was consent and the understanding around that.
Okay, interesting. Well, luckily for our clients, Lightstone has developed a number of different resources to try and help our estate agents in the adaptation to the law. We do want to caveat that we are not offering legal advice. These are resources to try to support your understanding of it. It's available to everybody for free on our website.
And the link will be popping up in our chat, so just look out for it. And you can just basically click on that URL and it'll take you to all the information that we've actually provided on POPIA.
Great.
And also probably, so what has happened in the first year of law being in effect? Have we learned anything new, gotten any further clarity?
So the law is governed by the Office of the Information Regulator, and the regulator's office has actually been quite busy in this first year. I have pulled out a few highlights on a couple of slides, if events can please share the slides. And I've separated them into a couple of general things that the regulator's been working on. And then also some direct marketing things coming after that. So Eric, would you mind sharing the slides, please? So while that loads, on the general side, a lot of times when you're introducing a new law as far-reaching as this, one of the important things is to help people's awareness. So the regulator's done a lot of activities that have been aimed at informing and educating the public and sharing knowledge. So they've done road trips and conferences throughout the countries, and also responded quite quickly to some media events or some things that have been eventful in the media around topical incidents, and used those to help to broaden awareness. So the pictures there, as you can see, a picture of Zuma in prison. We'll get onto that in a moment. But then also she's ratified a few codes of conduct for some significant industries, and codes of conduct can be used by industries to publish collectively how that industry is going to adhere to POPI and how they plan to do it. And then if it's ratified, then that forms a part of that industry's compliance with POPI.
All right, Linda, I actually remember the Zuma thing. So she actually warned the public around sharing photos of Zuma in prison, as this was basically his PI. That's
exactly right. A photo is construed of yourself is construed as your own personal information, and the sharing of it does need to conform to the requirements of POPI. And also, more recently, there was the media or the news event of the Krugersdorp and the regulator noted some irregularities about how the personal information was shared by the South African Police Services. So she's definitely using those publicized events to help to broaden knowledge for everybody on how this impacts people.
And then I see second on the slide is breaches, which is another focus.
Absolutely. So as I mentioned, the misuse of data is one of the key reasons why we need privacy law, and the availability of everything digitally exacerbates that. So she has actually, the office has reported more than 330 data breaches in the last year of POPIA being in effect. In POPIA, responsible parties, and that's the party that collects the personal information and decides what to do with it, they actually now have a legal obligation to notify the regulator if there's been a breach or even a suspected breach of personal information. And the regulators paid particular attention in the media to a large TransUnion breach that actually happened over a year ago, and the impact of this is still ongoing. And then also, because of the volume of breaches that have happened, 330 is quite a lot. The regulator has recently announced that they're going to set up a dedicated security compromise unit that's going to be responsible for investigating security compromises.
And this is obviously serious.
Absolutely, but it's a very positive thing for all South African citizens, because I think probably everybody knows somebody whose identity has been stolen and then used to perpetrate fraud on them, steal money from their bank accounts and so on. And this can have really wide-reaching consequences. It can actually just destroy people's livelihoods. So I think it's very important that there's a heavy focus on this.
Okay. And then looking at your third component on the slide, your registration portal.
Yes, so every responsible party, and this is relevant for our state agents, every responsible party has to have an information officer. And that information officer is responsible for ensuring compliance with POPIA. So leading up to the advent of POPIA, the portal had been having technical difficulties, and the regulator had to give relief to everybody from the obligation to register your information officer by the advent of POPIA's applicability. But now the portal is up and running, and every responsible party who manages personal information in any way needs to register the information officer formally. This is one of the first conditions of lawful processing of the 8 conditions. Speaking to accountability. So if any of our guests here on this webinar haven't done that yet, you should go ahead and register your information officer on the portal.
Okay, so moving on to the hot topic, direct marketing and the related changes.
Yeah, Eric, if you can move slides, please. So direct marketing is one component of POPIA. There are all of the 8 conditions for lawful processing apply to absolutely any time that you process personal information. In addition, there's a specific section for direct marketing. And that obviously is very pertinent to property practitioners. A couple of months ago, the regulator reported in a media event that her office had received up to that point, so end of June, I think, about 700 complaints from people about privacy invasion, about personal information misuse, and most of the complaints related to direct marketing.
I guess that's to be expected. And was there any level of detail?
Yes, so in the same speech, the regulator said that she acknowledged that actually there were some elements of section 69, and that's the section that relates to direct marketing, that are currently unclear, which there are. We understand this. And she committed to releasing a guidance note on direct marketing. Guidance notes are intended to give guidance to people on the interpretation or clarification of a law.
Okay. And did you mention any of the specifics that were unclear in that section?
There was one thing that was called out in particular, which is, she mentioned it's unclear in the Act whether telephone calls are considered electronic communication, because the direct marketing section speaks to regulations on electronic communication. And if telephone calls are considered electronic communication, they will be subject to the direct marketing rules. This is an element that's a little bit unclear now.
This is a common question that we do get a lot of. And it does obviously create a lot of uncertainty. So did she give any further direction of what to expect?
Not within that particular media release, but she did say that she's going to issue a guidance note on this and potentially other aspects of Section 69 on direct marketing. And then she's going to consult with the relevant stakeholders when she's drafting the guidance note.
Okay. And maybe just for all of the property practitioner clients out there, was there anything else of importance that relates specifically to direct marketing?
In that same speech, she did emphasize that data subjects must be contacted only. So if this is unsolicited direct marketing, you can contact the data subjects only once, and it must be for the purpose of obtaining consent. And the responsible party that's calling them must have obtained the contact details lawfully. She did underscore that buying contact details from a data broker is unlawful. But this is some element, I think, that will require some clarification as well.
We also get a lot of questions around that as well. And really, property practitioners shouldn't just contact people to inquire about listing their homes and assume that specifically if that owner does not ask to be contacted, that it automatically means that they have their consent.
That's right, yes. The regulator was very clear on the fact that the first contact must be used to obtain consent. You can't assume consent if people just don't say that you can't contact them.
So I suppose we're eagerly waiting for kind of the guidance note that will provide more clarity specifically on the marketing section of 69.
Absolutely. It can't come soon enough. I'm sure most of our clients simply want to understand what is required so that they can adhere to the law. And a big bulk of our clients' questions to us in the survey leading up to this webinar were about what they can and can't do with direct marketing.
I've got two questions that I'm going to just position from my side, and then I'm going to hand over once again to Esiani. I think the slides are all now done. Great. So what if someone from the agency that you're currently working in contacts a person? Can the estate agent, can another estate agent contact the same person?
I see. Yes, that's a very good question, and it depends on how the agency works. So the law applies to a responsible party. So if the agency is a registered organization and they are the responsible party in terms of POPI for processing that personal information, then every agent who is acting within the capacity of that company, it falls under the remit of that responsible party. If one agent, therefore, within that agency has called somebody and they've said, please don't contact me, then somebody else within that agency can't, because it's still the same company operating as the same responsible party. But if you are an agent, if each of you is registered as a company in your own right, then you are different responsible parties, and each party needs to fulfill the requirements of POPIA, and each party may call to see if they can obtain consent to call further.
And just another question. So if I, as an estate agent, have a database with clients' personal information, am I allowed to store this database on cloud? And may I send WhatsApp birthday messages, happy anniversaries from my mobile phone?
Wow, there are actually quite a number of questions and aspects to deal with in that. If you have a database with personal information, you first need to understand whether you have the right to continue to store that personal information under POPI. And for that, you need to step through all of the 8 conditions of lawful processing, one of which is to understand what is the nature of individuals whose details are on that database, and I'll come back to that in a moment. And the other one is what is the purpose that you collected it for, that you then need to adhere to POPI requirements on. POPI, if you have a database that you're using for direct marketing purposes, we can effectively divide the requirements into 2 sets. And there is a lot more information within our handbook for estate agents or property practitioners that we have available on our website. And I do encourage you to read that, and our clients to read that in more detail. But basically, if somebody is or was a client of yours, in other words, there was a service that was exchanged, then you are allowed to continue to contact that person in line with the original purpose of collection of data without seeking consent. You do need to offer an opt-out each time you communicate or direct market to that person. But I want to make the distinction between those people who are your clients versus those people who you haven't engaged with on a service, because then that is unsolicited direct marketing. Now, regardless of which one it is, so if you collected their data for the purpose of them being a client and you needed to engage with them for the transaction of a house, then you need to understand whether it's okay to send them messages. You can send them a birthday message. They are a client of yours, but you need to offer them the option to opt out of those types of communication. If you are, if they are not a client of yours, then everything about unsolicited direct marketing applies, and you need to seek consent before you can contact them for any purpose.
Okay, thanks, Linda. I'm going to hand over now once again to Esiani, just to pick up on any questions that have come through the chat.
Awesome. Okay, so not many questions around POPIA at the moment. I think the one question that we do have is when I do have my book for direct marketing, so the first contact, there are, you know, how do I as an agent keep track of whether there was consent or not? And I think the answer, Linda, is purely that it has to be managed internally to make sure that, you know, you do have a view of who have actually given consent to be contacted or not.
That's exactly right, Estiani. When you collect consent for direct marketing, it needs to be in the prescribed manner and form. And there is actually a document in POPIA, it's called Form 4, which outlines the type of information that you need to collect in order to gather consent for direct marketing purposes. Just want to touch briefly here on the topic of consent, because I think it can be confusing. When you are a responsible party dealing with any type of personal information, you need to adhere to the 8 conditions for lawful processing. One of those relates to your purpose or your justification for processing. You need to have one of the 6 legal grounds for processing that personal information. And one of those legal grounds could be consent. There are others which might be more appropriate for some types of processing. For example, you have a mandate with that party, and that's basically a contract. And in executing on that contract, you need to process their personal information. So consent is one of the 6 legal grounds for processing personal information when we're talking about general personal information. When you're talking about direct marketing, in order to direct market to people, you specifically need to have consent. And when you collect that consent, it needs to be in the prescribed manner and form called Form 4. And we do have a copy of Form 4 up on our website, along with all the other POPIA resources, if our clients need to refer to that.
Definitely. Thanks, Linda. And one of the questions asked here was, once I've gotten or received that consent, how long is it valid for? Is it a year? Is it a month? My answer, or I guess it would be as long as or until that person revoke consent. But if you have any more insights to share on that, maybe.
Great. Sorry, I did forget to mention in the previous answer, and I think it'll help for this one, that you don't have to capture, there's nothing in the act that says that you must get a physical written consent. But if it comes down to somebody saying, I didn't give you consent, and you saying that they did, the law is going to side on them if there isn't evidence of them having given consent. And that evidence of them having given consent is that Form 4, and it tells them who you are, it tells them why, for what purposes you want consent, and how you're going to use it, what you're going to process their data for, and so on. So then leading on to the latest question that you asked is, the consent needs to be specific, voluntary, and informed. So informed means telling them what you would like to direct market to them for. Specific needs to be that what you're going to direct market to them for is specific enough. You can't just say, I want to advertise any products or services to you. That's not specific enough. And then voluntary, obviously, they need to have the right to say no to, so that the consent mustn't be coerced. You can't just write into your services that you will only provide a service for them if they enable you to use their contact details for direct marketing purposes. So it needs to be specific, voluntary, and informed. If you tick those boxes of specific, voluntary, and informed, then it applies for the things that you inform them about, that you specifically are marketing to them, until they say no. So you were correct in that. But that doesn't mean that you can take that consent and apply it to things outside of what they're given consent for.
Definitely. And that answers another question from an attendee today, is to say, can anyone collect biometrical or data such as biometrical data from yourself without consent? So Facebook facial recognition, and the answer was very clear that it has to be there has to be consent, and it has to be clear. But on that, so we have posted the links into the chat as well to collect the 8, or to refer back to the 8 points of processing that, Linda, that you've referred to, which is one of the questions. But then another question was raised with regards to the POPIA compliance officer. So do you have to have a POPIA compliance officer per agent or per office or per branch? So is there a limit in terms of how many people can be governed by the compliance officer? If you can just maybe give some confirmation around that as well.
So the requirement to register an information officer is per legal entity. It is per company operating as a legal entity. And each one must have an information officer, but there isn't a limit on how many information officers they can have. There will always be only one official information officer who's responsible for ensuring compliance to POPIA, but that person may deputize any number of other information officers. And the deputy information officers are also responsible and liable, and their names will also be on the registration of that company. So for example, in Lightstone, we have a number of deputies because of the people who are responsible for various different areas. Like we've got somebody who's responsible for security. Security is very specifically one of the requirements, and because of the nature of data that we manage, it's important that we have ownership and accountability and responsibility around that. Myself as a deputy information officer, I think that we've got 4 or 5 deputies and 1 key one. So there's no limit to numbers. What I would suggest is that it needs to be on a practical level. If somebody manages certain functions around POPIA or carries certain responsibility outside of just everybody's responsibility for the adaptation and the compliance of POPIA, then they should have their name on as an information officer or a deputy on the registration.
Awesome. Another interesting question, which I think is very relevant, is that if the listing agent and selling agent are from 2 different agencies, are the agents allowed to ask for and keep the other agent's client's FICA documents? So, from a POPIA perspective, is it allowed to keep those documents in terms of the transaction that is happening?
Do you mean, are you allowed to retain that, or may a party that's not the engaging party store it?
Correct. Yes.
So in terms of are you allowed to retain it, POPIA, one of the conditions is retention, and that is that you may only keep personal information for long enough to execute on the purpose of having processed that personal information, and after that you must destroy it. So there is no specifics within POPIA about how long that is. You need to decide for your purpose, how long is it necessary for that purpose to retain the data. If that purpose is complete and you no longer have a requirement for that purpose to keep that data, then you should delete it. In terms of may other people host that data for you, if you are the party that's collecting that personal information to execute on a particular purpose, then you're the responsible party, and the full weight of the 8 conditions of lawful processing reside with you. If you require that somebody else supports you or helps you with that, and it involves touching the personal information that you're responsible for, then they are your operator, and you need to have a contract with them telling them what they may or may not do with that personal information, and they are compelled to keep it as secure as you are keeping that personal information. Other than that, they may not do anything else with that. So if I'm asking somebody else to hold and retain some of that information, then I must have a contract with them outlining what they can and can't do, and they must delete it when that purpose is complete, and they may not do anything else with it.
Great, thank you so much.
Cool. Thanks, Estiani. Thanks, Linda. Thank you for all of the information and the insights. I think it's really important that we just stay on top of both of these acts in terms of what's happening. And just also thank you once again to Silna, and thank you to Estiani for fielding all the questions. Just before we close out, just in terms of the survey, so if you just complete the survey and get that back to us, just also a reminder, you can get certificates for this for CBD points. So please just let us know on completion of survey, we can send you a certificate. So I'm really looking forward to kind of getting some feedback and understanding any further questions from your side. Anything unanswered, we will respond and put it through either our newsletter or a way to get through to everybody. But once again, thank you very much for attending our webinar this morning, and have a wonderful week for the rest of the week.